Well, this is indeed a continuation of our first grade conversation. We have three other spectacular historians to introduce briefly. I want you to note the names of their books because I'd like you to read them. That is your homework, and these are just definitive books, which I'm so delighted to introduce you to now, if I pick the right introduction sheet. Here we go. Martha Jones is the Society of Black Alumni Presidential Professor, Professor of History, and Professor at the SNF Agora Institute at Johns Hopkins. She's the author of Vanguard, How Black Women Broke Barriers, Won the Vote, and Insisted on Equality for All, and Birthright Citizens, A History of Race and Rights in Antebellum America. And I can't wait for her next book, which we're going to help launch here at the Constitution Center soon. Dylan Penningroth is Professor of Law and Alexander F. May T. Morrison Professor of History at UC Berkeley. He's also Associate Dean of the Program in Jurisprudence, Social Policy, and Legal Studies. He's the author of Before the Movement, The Hidden History of Black Civil Rights. And Kate Masur is John D. MacArthur Chair and Professor of History at Northwestern. She is the author and editor of many great books, including her most recent works, Until Justice Be Done, America's First Civil Rights Movement from the Revolution to Reconstruction, and Freedom Was in Sight, A Graphic History of Reconstruction in the Washington, D.C. region. Let's begin with a round giving the essence of all of your marvelous books, which in different ways tell the stories of unsung heroes in a civil rights movement that began more than a century before the one in the 1960s, and that's during the antebellum era. And each of you have done so much to bring to life these unsung heroes and tell their stories and teach us how they contributed to the meaning of Reconstruction and to the 14th Amendment. Kate Masur, you do such a great and vivid job on all of those antebellum abolitionists contesting over the meaning of privileges and immunities in the antebellum era. Maybe just pick a few great people and tell us their stories and how they cast light on the 14th Amendment.
Sure, thank you. And I just want to thank you for inviting me here, and it's wonderful to be here. And I guess I want to just start by saying how I came to that book, Until Justice Be Done. My earlier work on my doctoral dissertation and first book were on the Reconstruction era. And I later realized, as I was deep into what became Until Justice Be Done, that while I was writing the introduction to my first book, which was on Reconstruction in Washington, D.C., I wrote this line that was sort of like, I realized that Congress had not only abolished slavery in the District of Columbia in 1862, but had quickly gone on to repeal the black laws of the District of Columbia, which would have rendered, and already did render, free black people there sort of like a second class of people, a kind of without the full rights that white people were supposed to have. So Congress, again, the Republican-controlled Congress, not only abolished slavery, but then immediately repealed these black laws, which meant that it was kind of creating a condition of legal racial equality. And I wrote this line in my first book that was sort of like stating that they had repealed the black laws in DC without debate. And then I sort of thought, why did they do that? How did they think in 1862 that they were ready to not only abolish slavery but repeal the black laws? And who has written about why the Republicans came into Congress in the Civil War period already poised to do something like that, when you would think from a lot of the historical literature that the Republicans were they were indeed a kind of coalition of people, the white Republicans, who didn't all agree about everything. But you would also think that they were a party that really cared mainly about not supporting the extension of slavery into new territory. They were, according to the prevailing historiography, quite racist on the whole, didn't support racial equality, even if they supported stopping the spread of slavery. So why were they poised to just go ahead and repeal the black laws of DC? And that's not what got me onto that project, but later, and when I was deep in the project, I realized that I was sort of answering that question that had kind of appeared to me as I was finishing my first book. So that is, what kinds of views did the Republicans come into Congress with in the election of 1860 that set them on a course, because they had a majority in Congress, because of secession, because of the Civil War, to not only, in the end, abolishing slavery, but also passing these new federal policies that the previous panel was just talking about, like the 13th, 14th, and 15th Amendment, the Civil Rights Act of 1866. And so I was sort of thinking about the pre-Civil War history of these, what became these Republican leaders, and I was also thinking about the growing move among historians to talk about something that I think Ira Berlin called the long emancipation, thinking about how actually the end of slavery in the United States began in the period of the American Revolution, when at the time of the American Revolution, all the states of the United States had legalized slavery. And so the first, what people sometimes call the first emancipation, began in the American Revolution period, and later as what we now know as northern states began to abolish slavery in a variety of ways, creating, in a sense, this sectional division over slavery, right? So you had to create a free North before you could have a sectional division of slavery over slavery. And so historians were writing about this first emancipation in new and interesting ways, and thinking about, you know, the ways that the North, the free states, were in reality a post-slavery society, right? So you actually have the emergence of a post-slavery North before the Civil War, and then what the Civil War does is create, you know, is result in the end of slavery in the place where it was most entrenched, where the most people were enslaved. And so, you know, the question that I had, it was what lessons from the post-slavery North did people learn, and did they then bring into the battle over slavery and emancipation, and the kind of what flowed from that during the Civil War and Reconstruction. So it turns out, or what I found and kind of put forward, was that there was indeed this big fight and the series of disagreements over what would be the status of free African Americans in the post-slavery North, and that many of the people who were involved in those struggles, that were mainly at the state level but not exclusively at the state level, the white political leaders of that, of what became the Republican Party, many of them emerged out of that first civil rights movement. So they, in other words, they came into Congress in the 1860s with experience arguing over precisely the issues about race and law and equality that had been on the table in the pre-Civil War period. They had ideas about what the Privileges and Immunities Clause should mean, the original Article 4 Privileges and Immunities Clause should mean for African Americans, or when it comes to race and equality, because of those fights, and they brought those into the Civil War and Reconstruction. They had ideas about what was wrong with the black codes of the North, and why those were unjust and needed to be abolished, because they had been fighting over those issues in the antebellum North. And so, unlike a kind of, I'm not saying that the sort of story that we know of what's going on in the former Confederacy in 1865, and kind of what Sherilyn was talking about earlier about, you know, shirts coming back and reporting on what's going on in Congress, looking at that, all that, it matters and really did inform the debates about the 14th Amendment and the Civil Rights Act, but so too did this prehistory of struggles over of the future and fate of free black people primarily in the free states. So that kind of frames out the book and suggests that, you know, the whole story is not just what happened in 1865 and 1866 and 67 and 68 and 69, but that the people, I mean, and think about it, like the people were living human beings who had experiences with these questions as they went into this really cataclysmic period. So they brought the ideas and the fights and the struggles that they had been involved in into this period. So I didn't really answer your question about the Privileges and Immunities Clause. I can talk about that too, but I just wanted to kind of give the larger picture a little bit.
No, that's great, and it's such a riveting and crucial story that it was, as you said, free black people asserting their rights in the antebellum period that gave the way to the Reconstruction amendments, and that's the subject of Dylan Penningroth's book too. We had a great panel with both of you about a year ago, And it was so fresh and surprising and memorable to hear the individual stories of the Black people who made the first civil rights movement, as you both call it. And Dylan, I was just reminding myself of the intro to your book. You talk about your 27-year-old uncle who in 1976 made a tape recording of his great uncle describing his relative who was a slave in Cumberland County, Virginia, and drove a boat across the river ferrying Confederate soldiers and was paid for it. And you say that story shows that Black people actually were able to enforce contract rights even when they were enslaved, and then that gives the way to this amazing book with so many vivid stories of individuals like that asserting their rights. Tell a few of those stories and why it's so central to understanding the first civil rights movement.
Thank you. And thanks to all of you for being here today. It's really a pleasure and a privilege to share some of these conversations with you. So the story that Jeffrey Rosen was just telling was of my uncle, Craig Baskerville, who interviewed his great-great-uncle, Thomas Holcomb. And Thomas Holcomb, on this recording, I have this little tape back home, he talks about his father, named Jackson Holcomb, who was an enslaved man in Southside Virginia, Cumberland County. And just as you said, the end of the Civil War, Confederate troops running through the woods, they have to get across the Appomattox River. He has a boat, so he takes them across, and when they get to the other side, the soldiers paid him. And I remember hearing this recording in graduate school. My mom gave it to me, and I thought, that's weird. Like, why, they've got all the guns, why would they pay him? And I wrote my first book that was about enslaved people's family relationships, community relationships, and property relationships during slavery and how that carried over into freedom. And what I decided was that that was an extra legal system of property ownership and contract making that sustained a set of understandings among Southerners that made it possible for these soldiers to not be surprised at the thought of having to pay an enslaved man for bringing them across the river. But where I think I would, in the book that I just finished before the movement, the one thing that I have come to understand or to believe is that it's not an extra legal system of property ownership and contract, but neither was it legal. Jackson Holcomb couldn't have enforced his contract rights. No way, he would have been laughed out of court. But what he had was privileges. And so there's this kind of interesting paradox within the slave system. Slaves had privileges that most Southerners recognized and acknowledged. They couldn't enforce them in court, but they were widely understood as having purchased within the same general system of understandings about what was property and what was a contract that white people's property and contracts participated in, right? It's just sort of the common sense of law that every adult person has. You can't go to court about it, but there are certain consequences for violating those. Now, during slavery, the consequences are quite modest, right? You can get away with this stuff. But what changes after emancipation is that now former slaves can go to court, and they begin to do so in droves. And so one of the things, the question that I started out my book to find out was, what did former slaves, what did Black people in the South and in the North, what did they do with civil rights? So we've been talking a lot about civil rights and the differences between political, social, and civil rights. But I wanted to see, what did Black people do with their civil rights, narrowly defined as property, contract, and standing? And so I started going around to county courthouses and asking to see the records. And they would usually let me in the back room, and I'd pull down these docket books, and I'd start copying down names. And by the time I was finished, I had 14,000 cases, civil cases, about 30,000 names. My research assistants and I looked up all those names on Ancestry.com, the electronic version, not the swab version. And by the end, we discovered that of those 14,000 civil cases, 1,500 of them involved African Americans. And this is going from 1872 through 1962. And in fact, you see an enormous number of cases in places where you might not expect it, like Mississippi and Virginia. And you see a great number of these in the period that we think of as the nadir of race relations, when there's lynchings everywhere, the 1880s, 1890s, 1900s. And so what I was trying to do is figure out, what did black people do with civil rights? And what they did is they tried to enforce them in court, not necessarily against white people, usually against other black people. So the things that I took away from this project were, one, that it's so important to focus on the local as well as the national. It's important to focus on state law and local law as well as federal law, constitutional law. And it's important, lastly, to focus on private law, because that is where most people, even in those days, tended to care about. That's what they cared about. Do I have an enforceable contract? And this is, of course, the other thing that's going on is that American law schools are sort of beginning to take their modern form, and contract law is beginning to modernize in the United States. Black people are going to court in this very same period. Their cases are not just in the local courts, but some of them are percolating up to the appellate courts, and they begin to have an impact on case law of property and contract. Now, you can't see it necessarily because legal professionals at every stage of the process treated race opportunistically, which is to say that sometimes they buried race and sometimes they lifted it up. So you think about the slaughterhouse cases. I think it's Justice Miller. He states pretty unequivocally that the 13th, 14th, and 15th Amendments are all about race. It's about the freedom of the African race. But then Justice McReynolds, in a later case, contract case, he gets the transcript of record, which clearly states on the very first sentence that the plaintiff is a black man trying to enforce contract damages for mental anguish. He buries race, and he refuses to talk about it. It's nowhere in the published opinion on Westlaw. And so you can see this again and again, both in constitutional cases and in private law cases. Lawyers, trial court judges, appellate court judges, and then treatise writers and law professors are constantly making decisions about when to put race into the record, when to talk about it, and when to take it out. They're not just erasing it, sometimes they put it in because they want to advance a certain legal argument. Sometimes they take it out because they want their holding to sweep more widely. That's why Justice McReynolds did that in Byers. So there's a whole bunch of things going on that have an impact that emanate up from the local to the state level and on to the national level that still are reverberating today.
It's a really powerful insight to emphasize the local, and it very much resurrects the first civil rights movement, these unsung heroes who, using the law in very strategic and practical ways, are ultimately able to transform the Constitution. Martha Jones, we just did a great panel at the American Revolution Museum last weekend where you told the history of racial equality from the founding, well, through the civil rights movement, so powerfully in 10 minutes, singling out a couple of heroes who we don't often think about, including Mum Bet, who sued for her slavery and freedom in Massachusetts, an enslaved woman known as Elizabeth Freeman. Abigail, John Jay's enslaved person who you wrote about in the New York Times. See, just for because I think it's so useful and also helps the National Constitution Center also put a spotlight on these heroes in the course of teaching this history. Single out a few of them and tell us how they transformed the Constitution and contributed to the Reconstruction amendments.
So thanks for that, Jeff, and thanks to the Constitution Center, thanks to the folks at the Federal Judicial Center for having us. I'll take you up on that. But I'll say first that I hope what maybe is beginning to become clear is part of what I think we all share, which is a perspective about where to look for the history of law, how to understand the history of law that extends far from the texts of high court opinions, of judicial opinions. Kate Mazur is telling us everything about the world of abolitionist activism and deliberation. Dylan is telling us about what happens in those local county courthouses. As I begin to tell my story, I think what you, I hope, begin to hear are the ways in which there are many sorts of Americans, if you will, who are engaged in the interpretation, the reinterpretation, the promulgation even of the terms of things like constitutions. So let me, if I could, come back to Elizabeth Freeman, because we were in a conversation about, of all things, the Declaration, which maybe today has become it still persists as a touchstone, still is appreciated as an aspirational text. We're about to, next year, embark on a year plus of commemoration, celebration that will include, for many Americans, a rereading of the Declaration. But it was true in the 18th century that the terms of the Declaration were far more than that. That there were Americans who believed that in the terms of the Declaration were words that could gain traction in American courts, words that did, in the case of the state of Massachusetts, become incorporated into a state constitution, and then take on lived meanings in the lives of enslaved people there. Elizabeth Freeman is enslaved in Western Massachusetts. She is then known as Mum Bet. She is enslaved in a very provocative, politically rich scene in which activists in Massachusetts are beginning to work through the terms of the Declaration, their own constitution, and these fundamental principles. What does it mean when we say that all men are born equal? Well, Freeman is an enslaved person, right, without her own literal access to courts, to judges, to constitution makers, but she's in the rooms and she's hearing these deliberations. She's hearing these principles be enunciated by the folks we often refer to as white propertied men, but she hears the resonances for herself. And when conditions in the household where she is held enslaved become extremely intolerable, she looks to those words, those ideas, finds herself a lawyer who himself has subscribed to these ideas, at least for himself and people like him, and they bring suit. And they win, which is to say that the court ultimately, now it's important, it's not the court that holds, a jury holds. And this is always important for me, right? That a jury hears her case and that of a companion case for a man named Brom, and conclude that that equality principle from the Declaration into the Constitution of Massachusetts means that slavery is not possible in the state of Massachusetts. And Freeman's case becomes one of a cluster of cases that really is the death knell of slavery in the state of Massachusetts, long before we get to the dawn of the 19th century. Here, as a last point, I want to emphasize, how do we tell this story? It's from shards of records from a local courthouse. It is from reminiscences of the family of the lawyer who had represented Freeman. It's from Freeman's will. She goes on to be a free woman, a property owner, heads a family, leaves philanthropic, modest but important philanthropic bequests. We learn from her will. This, for us, I think I can say, is are keys, essential keys to understanding the history of law, how something like the Declaration becomes not only part of a state constitution in its formal sense, but how someone like Freeman then helps us to understand what it means to breathe life into that text, to give it lived meaning. And so she is indeed one of those extraordinary figures who is memorialized over at the Museum of the American Revolution. I got to see the exhibit after we had our conversation, and it's wonderful.
Magnificent. Thank you for telling that story and inspiring us to learn more about it. After you gave that great talk last weekend, I started digging and found that her lawyer, Theodore Sedgwick, was a Federalist who'd supported the ratification of the Constitution, but then he ends up at the War of 1812 leading the Hartford Convention, which wants to secede because they don't like Madison. It's just the twists and turns are so striking, and that's why it's so exciting and important to learn about history. And we lawyers are not trained to dig deep into history, focusing instead on the text, but we're on a crusade here at the Constitution Center to teach history through storytelling and inspire people to dig in deeper, and you're a central part of that. Well, let's now take up the question of birthright citizenship. It was central to the 14th Amendment. The debates arose over debates over civil rights acts. Kate, what does the debates over the birthright citizenship clause tell us about its meaning, and where did it come from?
Well, one of the things that is noticeable about, well, all right, to back up, so I think one thing that we need to recognize is how ambiguous and sort of amorphous citizenship was at the founding of the United States. So first of all, the founders are making a transition from talking about, in the British case, being a subject of the crown to talking in the vocabulary of citizen of a republic. And as you all are probably familiar with, the term citizen is used several times in the Constitution, but it's never defined who is and who is not a citizen. One thing that interested me a lot in my book was the Privileges and Immunities Clause in Article 4, Section 2 of the Constitution, which alludes to state citizenship, which is a reminder that state citizenship, and this came up on the panel, Sherilyn Eiffel mentioned this earlier, state citizenship was really quite important, although also not really very well defined from the beginning of the United States. So I think first we have to sort of keep in mind that there was no single definition of citizenship at the beginning of the United States. Also that state citizenship was very much in play, and these questions about sort of who was a state citizen and what sort of rights and privileges did a state citizen, however it was defined, carry when they went to another state was very much in play. And then another thing is that for the most part, authorities believed that the tradition of essentially what we now call birthright citizenship from Great Britain carried forward into the United States. So there was kind of a taken for granted sensibility that if you were born in the under English common law, it had been the case that if you were born in the domain of the king, you were a subject essentially of the king, and they carried forward that idea into the United States, the idea that if you were born in the United States, you are a citizen in some form, although again, they didn't define very well what the nature of national citizenship or state citizenship. And then, however, there was this huge exception for free black people. So the presumption was in essence that a white person or a descendant of Europeans born in the United States was a citizen of something, like a state or the country. But there wasn't the same kind of consensus when it came to free African Americans And there were actually a lot of free black people and growing numbers of free black people as gradual emancipation took shape in the North and in the slave states. There were, as Martha, I hope will talk about and has written about a lot, in the case of Baltimore and Maryland in particular. So, you know, I want to pass the baton to my co-panelists here, but just to say that, well, I'll say one more thing, that in my work, the question of the state citizenship status of free African Americans takes a pretty big plays a pretty big role, because from roughly the 1820s and the Missouri crisis all the way up until the passage of the Civil Rights Act of 1866 and the 14th Amendment, the question of the status of free black people under the Privileges and Immunities Clause, Article 4, Section 2, is in play, right? And there's this really big ongoing debate about whether free black citizens of a state like Massachusetts or New York could carry their citizenship rights with them and had the right, for example, to travel from state to state or to settle in a state like Missouri that tried to bar the in-migration of free black people into the state. So this is like a kind of submerged debate that I tried to bring to life, that once I started to understand that this debate was actually hotly contested from the 1820s onward, I started to see it everywhere. It's in the debates over what becomes the Compromise of 1850. It is in the Dred Scott decision, even though it's not a primary part of the Dred Scott decision. And so when we get up to the point of talking about the Privileges or Immunities Clause of the 14th Amendment, which is part of the story of citizenship, we have to sort of understand the backdrop of this kind of ongoing discussion about the Privileges and Immunities Clause in the original Constitution. But to circle back to birth, so that's a question of who is understood as a citizen within the United States in this time period, and what kinds of debates are the people, the framers of the 14th Amendment and the Civil Rights Act responding to, that is a subset of the large, well, it's part of the question of citizenship, but the question of why and how birthright citizenship is codified, I want to sort of pass over perhaps to Martha, who wrote a book titled Birthright Citizens.
Love you to answer to Martha, and Kate just introduced this distinction between the rights of citizenship, which are those that you can carry from one state to another, which is why political rights are not rights of citizenship, because you can't vote in Virginia if you're a citizen of Maryland, but contract rights and so forth are, with the question of who's a citizen. And she said that Dred Scott said black people couldn't be citizens, and the 14th Amendment is designed to overturn that. There is a debate over the meaning of citizenship in the Civil Rights Act, and one of the sponsors stands up and says that it doesn't include those who are subject to foreign powers. Does that exclusion mean just kids of diplomats and Native Americans who are not taxed, as the conventional understanding has been, or might it include kids of people who are not here legally?
Is that me?
That's you. You wrote the book.
It won't surprise you, I need to go back just a little bit, because I think there are a few things that are important to know about how we get to the 14th Amendment. And the first is that before the Civil War, free black Americans have organized themselves into an independent political movement, excluded from sitting in state legislatures, excluded from sitting in Congress. They form what we have come to call the colored convention movement, state and local and national meetings in which black Americans gather to debate the issues of the day, to strategize, to insert themselves into political culture, even as they are formally unwelcome. And one of the questions that surfaces very early in those meetings in the 1820s is the question of citizenship. So why? Why are black people preoccupied with the question of citizenship? As Kate says, it's sort of amorphous, it's sort of assumed. They are concerned because by the 18-teens, what has also solidified in the US is a political movement called colonization, led by the American Colonization Society. And the American Colonization Society is organized at its core to preserve the U.S. as a white men's nation. What does that mean? The colonizationists anticipate slavery is ending in the North. It is likely to end, perhaps in years, perhaps in decades, perhaps after a century. It is likely to end thoroughgoingly. And when it does, colonizationists are there to remove Black Americans from the U.S. They propose the Caribbean. They propose Mexico. They land, very importantly, on Liberia in West Africa, what is today Liberia in West Africa. And Black Americans are living with the prospect, the threat, the presence of forces that are organized to remove them from the U.S. And they believe that citizenship, right, that citizenship might be the bulwark that will save them from arbitrary removal without offense and without cause from the United States. And they promote, ultimately, this principle of birthright. They read the Constitution and they know that the president is a natural-born citizen. And they say, why aren't we? There's no color line in the Constitution. And this principle gets worked and worked again. We see it first in 1862 when Lincoln's Attorney General, Edward Bates, is asked a question: can a free Black man pilot a ship of the coastal waters of the United States? Well, he only can by federal law if he's a citizen. And Bates, in a long and very learned opinion that really summarizes decades-long debates over citizenship, says indeed, yes, he can. And this is the beginning of a pivot, right, at the federal level. We see it again in the Civil Rights Act of 1866. Birthright citizenship is there. And finally, the principle is constitutionalized. I'll try just very briefly your question. Right? So what's going on here with the 14th Amendment? Whose citizenship, for what purpose? We heard this morning, very rightly, right, that in part Congress is looking to now undo the force of the Dred Scott decision. But it doesn't write the 14th Amendment by those particular, we might even say narrow terms. Congress knows that this 14th Amendment and the birthright principle will now apply to all persons born in the United States. That will include the children of immigrants, be they immigrants from the Caribbean, be they immigrants from Europe, be they immigrants from even parts of the world not wholly anticipated. But most importantly, for the rest of the 19th century, I think, for this particular amendment, it is knowingly written by those terms to include the children of Chinese immigrants born in the United States, people who, by federal law, will be excluded from naturalization. Their children are unequivocally citizens of the United States, and we learn that from the Supreme Court finally at the end of the century.
Superb, very helpful history, a great way to introduce it. If this were a We the People podcast, we'd have arguments on both sides of the legal question that's being considered today about whether or not the Womkin Ark case should be overturned and birthright citizenship should be revised. But this is a great introduction to the deep historical debates that gave rise to the case today. Well, I want to take a round as we conclude this great panel on what historians can teach judges when it comes to contested questions of history. Maybe just focusing on what you think would be the most basic question in all of constitutional law, which we talked about in the first panel. Is Brown consistent with original understanding? And you heard disagreement even among our three panelists this morning about that question. I remember having the privilege of one great dinner with Justice Scalia, the one time I had the honor of meeting him, and I screwed up my courage late over drinks. And I said, Justice Scalia, you know, you're an originalist, but someone stood up in Congress and said, this isn't going to affect schools. How is Brown consistent with original understanding? He paused for a second, he threw back his head and he said, you know what, no theory is perfect, which was a great answer. But you heard this morning, Kate, Elon says, don't look at the original understanding. And what people said in Congress, look at the text, and the text is colorblind. And Sherilyn said colorblindness isn't in the text, nor is you need a background principle, and the anti-caste principle is the right principle. And I think Pam was judicious, but not directly weighing in on that question. But given it seemed that all three of our panelists were saying there's an essential disagreement when the amendment was passed about how broadly it would sweep, what principles it was meant to instantiate. Given all that, is there a single best meaning of the text? And now that historians, including all of you, are being asked to file briefs and weigh in on contested questions of Reconstruction history, what light can you really offer to judges? Kate?
Small question.
I think you all want to talk about it. So.
I mean, I think, okay, so in my view, first of all, historians are not judges, and we also are not really responsible for or necessarily interested in coming up with a theory of constitutional interpretation. That is your job. And what I feel that I do is try to ask questions about the past and illuminate the past in ways that are not actually driven by a desire to influence court cases. And then insofar as the areas of my expertise are relevant for things that come up in court, I'm happy to provide my expertise. But I have views on, constitutional interpretation, but that's not my lane, I think. And so I want to say a few things about how I think what historians do and how we tend to think and ask questions is distinct from what judges and lawyers and sometimes law professors do. So one thing is what I just mentioned, which is we tend to ask questions that are generated by, our own questions about the past and kind of trying to clarify what happened, maybe trying to write the histories of people who historically have been written out of history or not paid attention to in history, who we think deserve to have some attention on them, an interest in going into archives and finding new sources and figuring out what they can tell us about the past, an interest in engaging in conversations with other historians that, again, are not driven by desire to solve legal problems in the present, but are out of a kind of series of questions about, things like, a quintessential one is like, why did the Civil War happen, right? Like, or what is the nature of African Americans' resistance and to racism and to sort of structures of racism. So that's one set of things. But another is that we tend to be more interested, I would say, in context than in text. We are very interested in texts, but this, by definition almost, context really matters to historians, right? So the notion that we would go in and say, here's a sentence, and I'm just going to look at the words, and I am going to parse out what those words mean to me, and I might consult a dictionary to see what those words meant at a particular moment in time. Like, that's just really not the kind of work that we do. We are interested in the meaning of words, but we would also want to ask, well, who wrote those words? What political purposes were they written for? What was the person trying to do who wrote those words? What are the surrounding words? words? Where was this text published? Who criticized it? Was it authoritative? Was it, did people contest it? So that's one thing, is the kind of text versus context distinction, and I think we are often very, very interested in context, and complexity is another one. So we are not driven to come down on one meaning often. We often will recognize that meanings are contested, and that the sort of texture of history is actually struggles, arguments, contestation, back and forth, people resisting, somebody saying something and somebody saying something else, and sort of the idea of fixity, and that we would be able to just sort of come down on this is the singular meaning of this text or event is not necessarily how we really roll. And there are really real reasons why courts have to do it differently, right? Or why lawyers are doing things differently. They are trying to fix meaning. They're trying to make an argument. They desire a particular outcome. And so when they invoke history, they often do things that rub us a little bit the wrong way, because that's just, we're not comfortable with that level of, we don't feel so secure. We actually come into history, one word that I really like that is, we come in with a lot of humility about the past and about the limits of our understanding, about the idea that we cannot know everything, that so much has been lost to us, that actually we are humble before this sort of complexity and expanse and the things we can know, but the things we also can't know. And so that's another way in which some of the uses of history in the legal context disagree or sort of feel not quite right to many of us who are historians. So yeah, I think, what I'm trying to say is that I'm not trying to say that never the two should meet or can meet. I actually think that these conjunctures are really, first of all, they're very important, especially as courts are turning toward originalism or history or the past. It's very important, I think, that we have these conversations, and I actually also appreciate them a lot, but I think that recognizing some of those points of friction or ways that most historians go about things, and the distinction, I think, is also really important.
Fascinating. Dylan, you've written an important work of legal history. What can't and what can historians teach judges?
I think Kate's absolutely right, that we historians, we come to the record with a lot of humility and with a set of different purposes. There's an important distinction to be drawn between the job of a historian and the job of a lawyer or judge. I also want to just underscore what Martha said a few minutes ago about looking not just at the Constitution or federal law, not just at appellate federal courts, but at the broad panoply of courts that are scattered all over these United States, all the way down to the local level. Those are so important. I think maybe one way that I could answer your question is by sort of tweaking it a bit and asking a slightly different but related question, which might go something like this. How revolutionary was Reconstruction, and in what sense? And I think my take on it, which I think others might disagree with, I think you and I have had some conversations about this as well, is that it was revolutionary in the world of the political. It was revolutionary in the world of the social, which was talked about earlier. But in the world of the civil, it may not have been so revolutionary, precisely because of this world of privileges that I talked about earlier, the participation of enslaved and free black people in the broad grid of understandings that underpinned white people's property and white people's contract relations. And so what happens in the 1860s, 70s, and 80s is that Republican judges, the same people who go in and they write the Reconstruction amendments, the other thing that they're doing is they're writing into the Constitution and into state law, state appellate courts. They're writing what the historian Bill Nelson calls the jurisprudence of anti-slavery, which is to say that they're writing into these cases and into the treatises a conception of slavery and freedom that is essentially a binary. Slavery is personal, race-based coercion, and coercion is an overseer with a whip. Unless you have an overseer with a whip, you are not being coerced. This obviously leads an incredibly wide scope for economic duress. What today, you might hear it described as business compulsion. In other words, what the judges of the 1880s and 90s are saying is that market exploitation, if you're exploiting someone through the normal operation of the market, that's perfectly okay. They're also saying that personal domination based on gender, age, or disability is also okay. What's not okay is using race to coerce people. That, and you can see in a case that's in many of the case books today, Wolf versus Marlton Corporation, using race to coerce is wrongful threat. Now, what's interesting about that case, Wolf versus Marlton, and I'll just end with this, is that the legal professionals who argue the case clearly understand that this is a case where there's a transaction where a couple, a white couple in South Jersey, just across the river from here in Philadelphia, they make a deal to buy a house, a tract house in South Jersey. Then the couple they get divorced, and now they want to back out of the deal. And so they tell their agent to go to the developer and threaten to sell the property to a person who the kind of person you will never sell another property in New Jersey again. Now, the judge in the case clearly understands that the threat is to sell it to an African American. And I actually talked to the son of one of the lawyers in the case, Arlen Spector. Shane Spector told me, oh yeah, they're talking about selling to a black person. That never shows up explicitly in the trial record, but it's strongly alluded to. The judge knows what's going on, and he alludes to it. But then when it goes into the case books, it somehow gets transformed into, from selling to a person of color, a black person, it gets transformed, this idea, into the threat is that they're going to sell the property to an owner who will convert it to an industrial use, which is a very different thing. And now it's in the second restatement of contracts as a threat to, if you read the note and comment on that, it's in the second restatement as a threat to sell to an industrial seller. But in fact, it was a threat to sell to an African American. So I guess the big takeaway that I would say is that when you're thinking about what lawyers and judges are doing, and they say that they're being colorblind, you should be very sort of aware of the larger context, this long history of legal professionals and litigants deploying race, not necessarily to get at black people, but to advance the legal doctrine or to win the case. They're deploying it for their own purposes. So that's sort of the kind of thing, the kind of context that I think that I can bring to this conversation.
Fascinating. Martha, the last word in this great discussion is to you, and for that reason, I'm going to ask you to answer both questions, both what can judges teach historians and how revolutionary was Reconstruction?
When I went to law school, I learned a story about birthright citizenship, and it went, Dred Scott to the 14th Amendment, done. Maybe some of you learned that story too. And as a historian, I was able to teach myself a different story. And I'll tell it, but I'll tell it with the preface that I think that part of what at least I'm driving at this morning is that history not only insists that the historian be humble, but I think it suggests to the judge a kind of humility as well. So we all know what Dred Scott was. But in my work, for example, I'm able to enter into the daily life and the intimate life, the family life of a justice like Roger Taney and learn how involved, how intertwined Taney's life was with free African Americans to help us appreciate that Taney understands fully the implications of his conclusion, black people cannot be citizens of the United States, in the lives of people who are not only abstractions, but his intimates. I'm able to remind you that there are two powerful dissents in Dred Scott. Dissents that not only reach back to decades of debate about citizenship in the United States, but that anticipate arguments that will gain traction and with the 14th Amendment become, indeed, as we say, the law of the land. I'm able to tell you that in those days, federal judges rode the circuit, and that members of the Supreme Court take their dissents out into the world and rule by way of them, despite Justice Taney's opinion in Dred Scott. I'm able to tell you that in my home state, the great state of Maryland, when in 1858, the state high court is asked to adopt the rationale of Dred Scott into its own jurisprudence, the court says, no, thank you. We are a state with 90,000 free black people. If we put them outside the law, we are inviting mayhem. And so our civil rights extend to black Americans in this state, even if they may not be citizens, even if they may not vote, contract, sue, the protection of one's person and property will be the law in the state of Maryland. I'm able to tell you, right, that in 1862, long before we get to the 14th Amendment, Edward Bates is already rewriting Dred Scott and, in essence, overturning it for all practical matters. I'm able to tell you that as much as the judiciary comes to mark Dred Scott as an exception, as an error, as a regrettable moment in many senses, including the long career of Justice Taney, men like Frederick Douglass are not going to let you forget Dred Scott. And part of why we remember Dred Scott today is that Douglass, in speech after speech after speech, reminds the nation how low it can go. It warns the nation against returning to the literal letter of Dred Scott, but to the spirit of Dred Scott. And when we remember the case today, we have Douglass, in a sense, to thank for that, not the judiciary. So as a historian, I can tell you those things. How that lands for you, I cannot say. But it is to strongly suggest, right, that there are many, many characters, there are many realms in which the Constitution, judicial opinions are being interpreted and thought and rethought and remade in real practice. And this might engender in you all, I imagine, frustration. Justice Taney was bereft at how Dred Scott was ignored. Some of you may know he pens a supplemental opinion, 50 manuscript pages. He's waiting for the opportunity for the next Dred Scott case to come before his court so that he can reiterate and double down on his arguments, because he has failed to persuade on the ground about that which appears so sure on the page. And for me, that is the power of history, to give us that kind of, I think, humbling perspective on the work we do, and a reminder that my work, like your work, will be judged by time and by next generations, and not only by the expediency of our own moment.
Beautifully put. What a powerful image. The limited capacity of the Chief Justice of the United States to influence history, hand printing copies of his own opinions in order to, in the wan hope that people will listen. And ultimately, though, you say, history is the judge. For casting so much light on history, please join us in thanking our panelists.